Okay, we're here on the case of Steve Johnson versus Hemel Chevrolet. Mr. Piper is here on behalf of the plaintiff, and Mr. Hessen is here on behalf of the defendant. And we're here on a motion to compel production requests filed by Mr. Piper.
Yes, Your Honor.
Mr. Piper, go ahead.
Thank you. Yeah, this is an age and disability discrimination case involving an employee who was employed from 1981 through June of 2019 when he was terminated. I sent out some document production requests in late January. The controversy today relates to one particular request, which is request to produce number 4, which is a very important request under the circumstances, wherein I asked for personnel records of supervisors or managers and employees. The purpose of that is because the credibility of the supervisors and managers are an issue, and of course the lifeblood of any discrimination case is comparator evidence, where you compare the treatment of people outside of the protected classification versus that of other people who are not terminated. And it's very important to get that information. The defendant responded essentially by saying plaintiff quit his job and that the documents were irrelevant. First of all, the plaintiff did not quit. He was fired. I have written evidence to that effect. And it's just mind-boggling to me how the defendant, you know, even if he had a colorable argument that my client quit, that he could just say, well, we have a defense, so we're going to deny you discovery. That's not cognizable at all. And, you know, I need the comparator evidence to be able to prove the case and proceed with depositions. You know, I spent most of my brief arguing the importance of comparator evidence in a case. And, you know, here, this is a small company. Everyone reported to the owner at the time, manager, Mr. Engel. So you have mechanics, you have service technicians, things of that nature, but presumably they're all subject to the same standards of performance and, you know, honesty and accountability and things of that nature. So I think they would all be relevant. We're talking about, from my understanding, 10 files. I could just have the defendant send me the files, or I could go to the defendant's attorney's office, take a look at the files, put Post-it notes on whatever documents I need and get them that way, or go to the defendant's business office and do the same thing. I'm flexible regarding how we handle that. But, you know, in this day and age of, you know, is it burdensome or what have you? Clearly not. We're dealing with 10 files and it could be easily handled. So there would be no argument that it's at all burdensome whatsoever on the defendant. And it's extremely important for the plaintiff to obtain the information. I really don't see any defense to this motion. I mean, it's comparator evidence is something I need in order to proceed in the case. If the court has any questions, I'd be happy to address it.
Mr. Hessen?
Your Honor, there isn't any comparator evidence. I have attached the affidavit of Todd Wisser, who is now the president at Hemel's. There has been no request for accommodation for anything from any employee at Hemel's for the time period that Mr. Piper requested, which is January 1, 2019 forward. So there is nothing to produce that would fit into his case. Now, I also will note he was not particularly clear that that's what he was looking for and what comparator evidence he's looking for, that I could go back and look for something. But given Mr. Wisser's affidavit, there wouldn't be anything anyway, because separate from the age, separate from the disability claim that Mr. Piper is asserting, there has been no request from any employee to do anything. So the only employee that had any issues in terms of accommodation because of a medical condition is the plaintiff. And obviously the plaintiff has his file, we've produced his file. There just isn't anything that we can do. And basically, Mr. Piper's position right now is because the company is small, we should have to produce everything, even if it's not relevant, even if it doesn't fit within the scope of the claims that he's asserted in this case. I have given him an affidavit. There's nothing to produce, and I think that this should end the issue.
Let me address that, Your Honor. The response of the defendant reflects a fundamental lack of understanding of what discrimination cases are about. Generally, the defendant comes up with some sort of excuse as to why the plaintiff was fired. Here, they claim he quit, which is total nonsense. So they're going to have to come up with something else, such as he wasn't a good performer, or he didn't have the proper credentials, or he talked back to the supervisor, or any number of things like that. So it relates to performance, credentials, things of that nature. So generally, to prove a case, what you have to show is that the plaintiff was treated differently from other people. Well, I have the plaintiff's file, obviously, and his entire career from 1981 through when he was terminated, there doesn't appear to be any disciplinary action in his file. So if I can obtain files of other people who have disciplinary actions in their file, for example, performance, lack of performance, or insubordination, or things of that nature, yeah, it's going to go a long way to proving that the reasons that the defendant will be asserting for terminating Mr. Johnson are a pretext for discrimination. I don't know what this claim is about accommodation. That's not what disability discrimination is. That's not what age discrimination is. What you have to show is that the plaintiff was treated differently. So if obviously I get personnel records that show that other people had either one or a string of disciplinary actions for performance, insubordination, and things of that nature, and my client has none, that goes a long way for the plaintiff to be able to prove his case, that he was terminated for no good reason. The real reason was age or disability discrimination. So without those files, I can't do my job. And that's exactly what the defendant wants to do here, is to keep me from doing my job. So I mean, the defense here is totally without merit regarding the production of the information.
Okay.
So,
May I respond?
This is not simply a failure to accommodate case at all. This is disability discrimination and age discrimination. And you prove your case generally by comparative evidence, unless you have an admission, oh, we fired you because of your age. That doesn't usually happen. So you have to prove your case by circumstantial evidence. Obviously, when someone works for a company for over 20 years or 30 years or whatever it was, and he doesn't have any disciplinary actions, that raises a question, what was the real reason here? So, so I need the comparator information to be able to present to the court, hey, look, this guy was disciplined 5 times, my client none, therefore it must have been discrimination.
All right. And Mr. Hessen?
I do. I understand Mr. Piper's argument. But the point is, we don't have anything. We don't have any acts of discipline in any of the files that we're talking about. And if I need to tweak the affidavit to address some of those things, he wants all of the personnel files for the pool of employees during the 2-year period of time. There's nothing in there that reflects discipline. I went down this pathway with my client. It just doesn't exist. Now,
okay, so then show it to him. I mean, he's not going to take your client's word for it that that's what they show. He has a right to see these, and so it's not how it works. Like, trust me, there's nothing in there for you to see, so you don't get to see them. Disclose the files as he's requested. It's a very limited time period. It's not, it's not like there's 8 plants and he's asking for thousands of employee files. He's asking for one plant or one business, limited time period. And as Mr. Piper says, these cases are proven by what's out of the norm. And so, and again, discovery is that it may lead to something relevant, not that it has to lead to something relevant. So, you know, it's an age discrimination case where he's looking for any factor that would support his argument. It's not a fishing expedition, and he's not obligated to take your client's word that, trust me, there's nothing there to see. So I will grant the motion to compel the documents, and if you want a protective order as Mr. Piper offered, then, you know, then work that out. He's not going to disclose it to anybody, I don't assume, and he's not going to use it for any ill will, and you two can work out how that's to be done. But I grant the motion to compel.
Your Honor, may I clarify something? I asked for the personnel records of the people from 2019 to the present. I wasn't limiting the production, however, to the time period of 2019 to the present. For example.
No, I understood. Just the employees that are still there, but you want their entire file, not just 2019 to the present. So you don't need employees over the last 10 years that worked, you know, 2011 to 2012. You need the ones that are still there or worked there since 2019, but they're employee files.
Correct.
And then also the supervisors.
Correct.
That had any supervising over Mr. Johnson.
Just to be clear, my understanding is the only supervisor was Mr. Engel, and he was the owner, and he does not have a personnel file, but I will certainly verify that.
Okay. And again, if the records, you know, or if the discovery shows that there was somebody else under Mr. Engel, you know, although not titled in practice, bring it back to me. Okay? All right. So Mr. Piper, draft that order, and you two work